Annulment is a legal procedure for declaring a marriage null and void. Unlike divorce, it is usually retroactive, meaning that an annulled marriage is considered to be invalid from the beginning, almost as if it had never taken place. In legal terminology, an annulment makes a void marriage or a voidable marriage null. Void versus voidable marriage. A difference exists between a void marriage and a voidable marriage. A void marriage is a marriage which has no legal recognition. Such a marriage is automatically null, although a declaration of nullity is required to establish this. The process of obtaining a declaration of nullity is similar to an annulment process. Despite its retroactive nature, children born before an annulment are considered legitimate in many countries. Reasons for a void marriage may include, depending on jurisdiction, consanguinity, bigamy, group marriage, child marriage. A voidable marriage is a marriage which can be cancelled at the option of one of the parties. It is a valid marriage, but is subject to cancellation if contested in court by one of the parties to the marriage. The validity of a voidable marriage can only be made by one of the parties to the marriage. Thus, a voidable marriage cannot be annulled after the death of one of the parties. A marriage can be voidable for a variety of reasons, depending on jurisdiction. Forced, coerced marriages are usually voidable. In countries where marriage law is influenced by religion, there can be numerous reasons for a marriage to be voidable. The principal difference between a void and voidable marriage is that, in the case of the former, because it is invalid from the beginning, it can be voided ex officio, while in the case of the latter it is only the spouse himself/herself who can ask for an annulment. These differences are very relevant, because they represent the official policy on issues such as forced marriage, for instance. If such marriage is classified legally as void, then the state can cancel it even against the will of the spouses. If it is voidable, then the state cannot act in the absence of an application by a spouse, even if the state knows the marriage is forced. Christianity. Anglicanism. The Church of England, the mother church of the worldwide Anglican Communion, historically had the right to grant annulments, while divorces were only available through an Act of Parliament. Examples in which annulments were granted by the Anglican Church included being underage, having committed fraud, using force, and lunacy. Catholicism. In the canon law of the Catholic Church, an annulment is properly called a declaration of nullity, because according to Catholic doctrine, the marriage of baptized persons is a sacrament and, once consummated and thereby confirmed, cannot be dissolved as long as the parties to it are alive. A declaration of nullity is not dissolution of a marriage, but merely the legal finding that a valid marriage was never contracted. This is analogous to a finding that a contract of sale is invalid, and hence, that the property for sale must be considered to have never been legally transferred into another's ownership. A divorce, on the other hand, is viewed as returning the property after a consummated sale. The Roman pontiff may dispense from a marriageatum sed non consummatum, since, having been ratified but not consummated, it is not absolutely unbreakable. A valid natural marriage is not regarded as a sacrament, however, if at least one of the parties is not baptized. In certain circumstances it can be dissolved in cases of Pauline privilege and Petrine privilege, but only for the sake of the higher good of the spiritual welfare of one of the parties. The Church holds the exchange of consent between the spouses to be the indispensable element that makes the marriage. The consent consists in their human act by which the partners mutually give themselves to each other. I take you to be my wife, I take you to be my husband. Quote, this consent that binds the spouses to each other finds its fulfillment in the two becoming one flesh. If consent is lacking, there is no marriage. The consent must be and active the will of each of the contracting parties, free of coercion or grave external fear. No human power can substitute for this consent. If this freedom is lacking, the marriage is invalid. For this reason, the Church, after an examination of the situation by the competent ecclesiastical tribunal, can declare the nullity of a marriage, i.e., that the marriage never existed. In this case, the contracting parties are free to marry, provided the natural obligations of a previous union are discharged. Catechism of the Catholic Church, 1626–1629. Although an annulment is thus a declaration that the marriage never existed, the Church recognizes that the relationship was a putative marriage, which gives rise to natural obligations. In canon law, children conceived or born of either a valid or a putative marriage are considered legitimate, and illegitimate children are legitimized by a putative marriage of the parents, as by a valid marriage. Certain conditions are necessary for the marriage contract to be valid in canon law. Lack of any of these conditions makes the marriage invalid and constitutes legal grounds for a declaration of nullity. Accordingly, apart from the question of diriment impediments dealt with below, there is a fourfold classification of contractual defects: defect of form, defect of contract, defect of willingness, defect of capacity. For annulment, proof is required of the existence of one of these defects, since canon law presumes all marriages are valid until proven otherwise. Canon law stipulates canonical impediments to marriage. A diriment impediment prevents a marriage from being validly contracted at all and renders the union a putative marriage, while a prohibitory impediment renders a marriage valid but not licit. The union resulting is called a putative marriage. An invalid marriage may be subsequently convalidated, either by simple convalidation or by sanatio in radis. Some impediments may be dispensed from, while those to jure divino may not be dispensed. In some countries, such as Italy, in which Catholic Church marriages are automatically transcribed to the civil records, a church declaration of nullity may be granted the exequatur and treated as the equivalent of a civil divorce. Methodism. Methodist Theology Today, edited by Clive Marsh, states that, when ministers say, "I pronounce you husband and wife," they not only announce the wedding, they create it by transforming the bride and groom into a married couple. Legally, they are now husband and wife in society. Spiritually, from a sacramental point of view, they are joined together as one in the sight of God. A minute before they say the vows, either can call off the wedding. After they say it, the couple must go through a divorce or annulment to undo the marriage. Islam. Fasq means to annul in Islam. It is a Sharia-granted procedure to judicially rescind a marriage. A man does not need grounds to divorce his wife in Islam. To divorce, he can simply invoke talaq and part with the dua he gave her before marriage, or he can invoke li'an doctrine in case of adultery, by bringing 4 witnesses who saw the wife committing adultery, or by self-certify and swear by Allah 4 times. And Sharia requires the court to grant divorce requested by the man. Also, Sharia does grant a Muslim woman simple ways to end her marital relationship and without declaring the reason. Fasqa doctrine specifies certain situations when a Sharia court can grant her request and annul the marriage. Grounds for fasq are: for irregular marriage, forbidden marriage. The marriage was contracted by a non-Muslim husband who adopted Islam after marriage. The husband or wife became an apostate after marriage. Husband is unable to consummate the marriage. In each of these cases, the wife must provide 4 independent witnesses acceptable to the Qadi, who has the discretion to declare the evidence unacceptable. In Sunni Maliki school of jurisprudence, cruelty, disease, life-threatening ailment and desertion are additional Sharia-approved grounds for the wife or the husband to seek annulment of the marriage. In these cases too, the wife must provide 2 male witnesses or 1 male and 2 female witnesses, or in some cases 4 witnesses, acceptable to the Qadi, who has the discretion to declare the evidence unacceptable. In certain circumstances, an unrelated Muslim can petition a Qadi to void the marriage of a Muslim couple who may not want the marriage to end. For example, in case the third party detects apostasy from Islam by either husband or wife. In cases of apostasy, in addition to annulment of the marriage, the apostate may face additional penalties such as death sentence, imprisonment and civil penalties unless they repent and return to Islam. United States. State of New York law provides for incestuous and void marriages, voidable marriages. The cause of action for annulment over voidable marriage in New York State is generally fraud. There are other arguments. See the statute. Fraud generally means the intentional deception of the plaintiff by the defendant in order to induce the plaintiff to marry. The misrepresentation must be substantial in nature, and the plaintiff's consent to the marriage predicated on the defendant's statement. The perpetration of the fraud and the discovery of the fraud must be proven by corroboration of a witness or other external proof, even if the defendant admits guilt. The time limit is 3 years. This does not run from the date of the marriage, but the date the fraud was discovered, or could reasonably have been discovered. A bigamous marriage as well as an incestuous marriage is void ab initio. However, there is still the need for an action to declare the nullity of a void marriage, upon which the court, after proper pleadings, renders a judgment that the marriage is void. There may be effects of marriage such as a property settlement and even maintenance if the court finds it equitable to order such relief. State of Nevada. In Nevada, the qualifications for annulment include a marriage that was void at the time performed, lacked consent, or is based on some kind of dishonesty. See also Nevada annulment statutes. To file actions based on fraud, you must have separated from your spouse as soon as you learned of the fraud. Annulments in Nevada require a residency of at least 6 weeks, including a signed witness statement of having been living in Nevada for that amount of time. England and Wales. England and Wales provides for both void and voidable marriages. Void marriage. Spouse is a closely related. One of the spouses was under 16. One of the spouses was already married or in a civil partnership. Voidable marriage. Non-consummation. No proper consent to entering the marriage. The other spouse had a sexually transmitted disease at the time of marriage. The woman was pregnant by another man at the time of marriage. Section 13 of the Matrimonial Causes Act 1973 provides for certain restrictions in regard to the possibility of annulling voidable marriages, including where the petitioner knew of the defect and of the possibility of annulment, but induced the respondent to believe that he would not seek an annulment, or where it would be unjust to the respondent to grant the decree of nullity. There is usually a time limit of 3 years from the date of the marriage in order to institute the proceedings. Australia. Since 1975, Australian law provides only for void marriages. Before 1975, there were both void and voidable marriages. Today, under the Family Law Act 1975, a decree of nullity can only be made if a marriage is void. A marriage is void if one or both of the parties were already married at the time. The parties are in a prohibited relationship. The parties did not comply with the marriage laws in the jurisdiction where they were married. One or both of the parties were underage and did not have the necessary approvals, or one or both of the parties were forced into the marriage. France. In France, a country of Roman Catholic tradition, annulment features prominently in law and can be obtained for many reasons. The law provides for both void and voidable marriages. void marriage, forced marriage, underage marriage, bigamy, incestuous marriage, lack of legal competence of the registrar, and clandestine marriage. Voidable marriage, vices of consent, i.e., consent obtained under deception, by misrepresentation of one's personal characteristics, personal past, intentions after marriage, etc., where the deceived spouse discovers after the marriage the deceit, and failure to secure the authorization of the person who should have authorized the marriage. Multiple annulments. Henry VIII of England had 3 of his 6 marriages annulled. These marriages were to Catherine of Aragon, Anne Boleyn, and Anne of Cleves. Catherine Howard never had her marriage annulled. She had committed adultery with Thomas Culpeper during the marriage, and she had flirted with members of his court. Because of this, on November 22, 1541, it was proclaimed at Hampton Court that she had forfeited the honour and title of Queen, and was from then on to be known only as the Lady Catherine Howard. Under this title she was executed for high treason 3 months later. Controversies. The grounds of annulment in regard to avoidable marriage, and indeed the concept of avoidable marriage itself, have become controversial in recent years. According to a paper in Singapore Academy of Law Journal, where divorce is available to all, it seems somewhat inconsistent to favor some groups of unhappily married people by giving them the privilege of choosing whether to put an end to the misery by way of annulment or by way of divorce. It is also worthy of note that some judges, like Kumaraswamy J. in Chu IHWA, have noted that some of the grounds making a marriage voidable have tended to be abused by parties who hope the court will grant the petition on fairly skimpy evidence simply because the petition is not defended.